Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Today, if you look down below me here, I've got a little graphic. This is about, this is a graphic describing a case that went around Poll, it went around Twitter, it went around the internet. I think Roseanne Barr was even tweeting about this stupid thing. Anyway, it says, in case you didn't know, Twitter, Facebook, and Google are violating constitutional law with their excessive censorship. That is wrong. That is wrong. The case that they're talking about, you can not really read it very well in the picture, but is Marsh versus Alabama, and I have it pulled up next to me. But we are not going to read through this entire case. Though it is interesting, I feel like I can summarize it and hit the main points a little bit better and keep this video under 2 hours long. All right. It's not actually that long. It doesn't matter. Let's get to this. So, first thing to note, this is no longer good law. It hasn't been officially overturned by the United States Supreme Court. However, the circumstances, which we're going to read about really soon, do not, or I'm going to tell you about. We're not going to read that part, but I'll tell you about them. Those circumstances no longer exist in the practical way that they did in 1946. You'll find out very quickly what I mean by that. But I want you to bear in mind what was going on in 1946 and why the circumstances exist as they were. You had a bunch of guys coming back from war. They had not been at home working and earning livings and building businesses and doing all that stuff. So you had this weird period where an entire generation of people was coming back to the country and having to reintegrate into a country that was largely built on manufacturing and industrialization at the time, especially. So you had these companies finding different ways to get people employed and to give them places to be that were convenient for the employer. So they created company towns, and that's the situation you have here. So I'm going to start talking about this case now and why all of this matters, and why, more importantly, we're going to get to why this matters today. Because though this is not good law, and you can thank my stupid state and their need to have the Mall of America owned by Iranians who live in Canada, you can thank them and their need to protect the Mall of America for having the most negative treatment of Marsh versus Alabama and pushing us the farthest away from both God and the freedom of speech. But I digress. Let's get to this case, and we'll see why all this is important for how we start fixing the mess we're in now. Okay, so Marsh versus the state of Alabama. The state of Alabama, this town called Chickasaw, Alabama, which is a suburb of Mobile, Alabama, was a company town. Now, the company was Gulf Shipbuilding Corporation. You know, Gulf, like, I don't know if you remember these. They make giant boats, and they ship stuff across the ocean. And it says Gulf on them. So the Gulf Shipbuilding Corporation had this town. They owned every single bit of it. So they built this giant plant, this giant factory where all of its workers come and they manufacture these ships. And then they have the area around the plant, and they set up homes. They set up a business district, and they would rent out homes to employees. They would rent out business districts or the business space to companies or individuals who are entrepreneurs who wanted to sell goods and services. They had a police station. The police officer was actually paid for by the company, not the state. He was a city employee, but his salary was paid by the company. You had a post office that delivered mail to all of these people. This is all on private land owned by Gulf. No other private entities owned any of this. No one owned their little house inside Gulf's realm of terror. It was just Gulf. And they, would lend out. And this is a very common thing, right? Gulf isn't the only company to do this. All of the major auto manufacturers had company towns. A lot of these large manufacturing operations did this because, like I said, you had a generation of people coming back. They didn't necessarily have the resources to move themselves across the country, buy homes. They didn't have credit was a completely different thing. They didn't have these stockpiles of money. All of this stuff was very different. So this gave them a way to say, one, we can pay lower wages and we'll own this property and give rent as part of the wage to our workers and all this stuff. So you've got this company town, but it's important to know that Gulf owns all of it. There are no little bastions of freedom inside Gulf Town or any of these other company towns. So what happens next is you have a Jehovah's Witness, because don't you always have a Jehovah's Witness? You'd be shocked how many free speech cases we owe and how much freedom we owe to the Jehovah's Witnesses' real burning desire to bother you by handing out a Bible tract, right? We owe them, quite frankly, a great amount. A great amount of debt is owed to them in the speech capital of the American society. But anyway, so you have this Jehovah's Witness. This is Marsh. And she is on the sidewalk in this company town. She's on private property. They owned the roads, right? Because shockingly, you don't need a government to build roads. I don't know how everybody forgot this, like the libertarian meme argument of, well, you know, what are you going to do without roads? Companies used to build them all the time for their own private use, and then they would allow the public to use them under sometimes circumstances like payment. Other times they just donate it to the public because they needed bigger roads to ship their goods. It's weird how freedom works. Like when you... If you want better roads, get the government out of control and put Amazon's delivery service in control. You'll get better, more efficient roads pretty quick because they want to deliver their products, right? That's the theory of all of this. And prior to 1955, Eisenhower had not actually constructed the interstate highway system. So we didn't have this like government road megastructure that we enjoy today. So Gulf had roads that they owned as well as all of the other aspects of the town. And they own the sidewalks. They own all of it. There's no government here except the government of Gulf. So Marsh comes in and she is handing out Bible tracts. She's knocking on doors. She's walking down the sidewalk, talking to people, trying to spread the good news of the Jehovah's Witnesses, right? Now, there's an ordinance, a state ordinance or state law, I guess, in Alabama at the time that says that, or I shouldn't say it says this. It's a trespassing law, right? It's a trespassing law. But the entire city of Chickasaw, owned by Gulf, had a rule that said this is private property and without written permission, no street or house vendor, agent, or solicitation of any kind will be permitted. So you had to go to Gulf if you wanted your freedom of speech on the sidewalk to hand out material and solicit people, to invite them to participate in something. You could surely talk to other people, but you couldn't pitch them an idea or a sale or anything like that without getting a permit, without getting express consent. Now, if you did this at a government level rather than a private company level, this would definitely be illegal. Obviously, it would be illegal for the government to try and stop you from evangelizing your religion on a public sidewalk to people, so long as you weren't, actually harassing them or committing some other crime. But if you're just out there politely trying to hand out Bible tracts or even mildly aggressively handing out Bible tracts and saying, do you know where you're going when you die, you stupid sinner? You say that stuff, that's probably still okay. So the government can't stop you from that. But Gulf reasoned that they could because they owned all of it. And on private property, you can set your own rules, right? We hear this all the time. It's their private property. They can do what they want. They can kick you off if you want. They can kick you out and then if they ask you to leave and you don't physically leave, you're trespassing, right? They've revoked your property right to be there. Interestingly, I don't know that we've actually had a trespass case against one of the major social media companies, but it will be interesting if they start to do it, or if they start to say that we banned so-and-so and they created a fake account to come back and circumvent our ban. that they're now engaged in the unauthorized access of a computing device in violation of interstate commerce, which would be, this would be a massive, that's a felony. If you're accessing something in an unauthorized way, you're looking at felony charges. So it's possible that we'll see these tech companies get to a point where they will ban someone. Like, what if Alex Jones created an alternate account right now on Twitter and got on and was like, hey, I'm Jalix Owns. I'm going to tell you about why frogs are not gay and why traps are gay, or whatever. Like, whatever because I wasn't looking at trap porn, right? Like, let's put that hypothetical. Jalix Owns comes on and creates a new Twitter account and gets another 1 million followers. They figure out it's Alex Jones and they say, whoa, you weren't authorized. We kicked you off of the internet and you are no longer a person, so get out. We may see something like that where they try to enforce some sort of internet trespass or claim that he's unauthorized violating, unauthorized access to the computer in violation of federal law, and then that the state needs to enforce. That would make this case really, really close. Right now, that's the biggest difference, in that Marsh versus Alabama involved a criminal charge of trespass when Marsh, the Jehovah's Witness, was asked to leave because her speech was unacceptable to the private entity that owned the property she was occupying. She refused to leave, saying that was a violation of her rights, so she was cited with a trespass. And here we are. That's the main difference. It's really, really important to realize that that's the main difference, is the enforcement of criminal acts, because as Facebook and as Twitter and as Google and Apple and all of these companies get more and more influence, they will inevitably look to the state to enforce when people find ways to circumvent their censorship. Okay, that's going to happen. If it hasn't already, it may have. I don't know. But what was killing me is I'm going through this case and I'm trying to just pick out some important stuff to summarize the positions, the thought that these justices had, not the thought, the perspective that they had that is gone today. It's gone. It's the idea that some rights like speech and religion and press are so crucial that we're willing to infringe on the rights of a corporation a little bit to protect the more important rights of speech. Now, you may ask if I'm making a value judgment on the level of rights here. I'm not, but they are. They are. And to all the to my liberal audience who may be opposed to Jalix Owns coming back onto the internet or whatever, this was written by Justice Black. Justice Black also wrote Roe versus Wade, I believe. So therefore, you must love it, right? That's how this works. That's how we draw unreasonable corollaries and then prove our points. I think. But anyway, let me get to these quotes, because listen to the justices lay down the sweet, dripping honey of freedom right on the toast of the American people through this opinion, okay? Because where did this go? I want to know. Like, I'm reading through this, just thinking, where are you? Where are you? Where is this perspective? Who remembers this? Who remembers this? Listen to these lines. We have recognized that the preservation of a free society is so far dependent upon the right of each individual citizen to receive such literature as he himself might desire, that a municipality could not, without jeopardizing that vital individual freedom, prohibit door-to-door distribution of literature. Okay? Listen to what they're saying there. Not only is it because this is coming after they've talked about Marsh's right to speak, but it's not just the right of the speaker to speak. It's the right of the consumer to receive the literature that the speaker is providing, or I guess the author is providing. When you can't access the content you want because that content creator is no longer allowed to speak, that is as much an infringement of your speech as it is of theirs. This is important. When Facebook throws someone that you follow off of Facebook, you're denied access. They're denied their access to speech, and you're denied access to their speech that you otherwise had. Okay? Next. This is crazy. This is crazy important to the case. Again, these quotes are all just blowing me away. Can those people who live in or come to Chickasaw be denied freedom of press and religion simply because a single company has legal title to all of the town? Think about what we're saying when we defend Facebook and Twitter's ability to deplatform people. Can the people who come to Facebook, because Chickasaw is Gulf Town, right? Can the people who come to Chickasaw replace Chickasaw with Facebook? Okay, can those people who live on or come to Facebook be denied freedom of press and religion simply because a single company has legal title to all of the website? Change it that way. Now, I know what you're thinking, because I have the same counter argument. You're thinking being in a town and having all of the services owned by the company is a little bit different than owning the website or the app of Facebook or Twitter or something like that. And yes, it is different. One has an essential set of functions that you need to live in a free society. But remember, actually, let me check. I don't think, I don't know if Marsh even lived in the town. This is important. It doesn't say if Marsh lived in the town. Here's how it describes her. Appellant, a Jehovah's Witness, came onto the sidewalk we have just described, stood near the post office, and undertook to distribute religious literature. Think of that. It doesn't say she lived there. Doesn't say she was, acquiescing to all of the rules of the town. For all we know, she drove to Chickasaw from somewhere else, walked on the sidewalk, and started handing out stuff. Jehovah's Witness, very possible that she traveled to expand her outreach to a place where she didn't live. Very, very possible that that has happened. More important, the court doesn't address it, which means that the court doesn't find it that compelling to determine whether or not she's there. This is crucial because she's voluntarily entering a private forum, right? Kind of like when you or I go on Twitter or Facebook or YouTube or anywhere. We're voluntarily entering the private internet property of these companies. It's very, she's not necessarily utilizing a phone line, a plumbing system, or anything like that. She's standing on a sidewalk. So those distinctions, while they are important, it is important to distinguish between a town and a website. The essential functions of the town that make it so important are not really at issue in this case. Okay, so bear with me. Sorry for the digression. Let's move on. Listen to this line. We do not agree that the company's property interest settles the question. Because that's always the counter argument. Well, it's their website. It's their website. They can do what they want. They can kick you off if they want. You don't have to use it anymore. No. The court says we don't agree that the company's property interest settles the question. Very big. Ownership does not always mean absolute dominion. Listen to this next line because I love it. The more an owner, for his advantage, opens up his property for use by the public in general, the more do his rights become circumscribed by the statutory and constitutional rights of those who use it. What do we hear from these communists who run these giant corporations? Zuckerberg, Jack, Tim Cook. What do we hear from these guys? We want to provide a service to our customers and to the public. We want to make Facebook the go-to place for meeting with your friends, family, keeping up, socializing. These are public services that they're putting out there. They're making billions of dollars. I think way more than Gulf Shipping ever made. You could fact mine me on that all you want. I don't know for sure, but I'm pretty sure Facebook and Apple are bigger companies than Gulf Shipping ever was. They're making tons of money, and they're circumscribing our right to participate in our constitutional activity, constitutionally protected activity. Think of that. I mean, listen to that line. I'm going to read it again. The more an owner, for his advantage, opens up his property for use by the public in general, the more do his rights become circumscribed by the statutory and constitutional rights of those who use it. Speech, speech, speech. If someone is opening up their property to the public for public use and consumption, then those public rights in some capacity come with it, and at some point they overbalance the rights of the private entity. Very important. Moving on. Thus, the owners of privately held bridges, ferries, turnpikes, and railroads may not operate them as freely as a farmer does his farm, since these facilities are built and operated primarily to benefit the public, and since their operation is essentially a public function, it is subject to state regulation. Listen to that. Roads, ferries, bridges, turnpikes, bridges, maybe a series of underground pipes where information goes, right? Like maybe that's similar to those. Now, I'm not advocating for like the internet to be classified as a public utility or anything like that. But if a company owns a road, or more importantly, as we'll get to in a little bit, if a company owns part of a road and opens it to the public, it then potentially becomes unlawful for them to close that segment of the road to the public later. When you open for business to the public, you get restrictions on what you have. We see this all over the place, right? Try to not bake a cake. Try to not bake a cake, and they'll tell you over and over again, don't open your business to the public if you want to have your free speech rights. But what's the exact same freaking argument that someone like Facebook or Apple uses? Our free speech rights are violated if we're forced to allow someone else to exercise their right on our property. Can't have it both ways. Can't have it both ways. Where you at, court? Where you at? And though the issue is not directly analogous to the one before us, we do want to point out by way of illustration that such regulation may not result in an operation of these facilities, even by privately owned companies, which unconstitutionally interferes with and discriminates against interstate commerce. If private facilities owns these public service thoroughfares like bridges, ferries, turnpikes, and railroads, if a private company owns them but opens them to the public, then they can't interfere with their constitutionally protected rights or discriminate against interstate commerce. Now, Justice Hot Dog disagrees with that last part, but he agrees with the first part. And we always listen to Justice Hot Dog. Had the corporation here owned the segment of the 4-lane highway which runs parallel to the business block and operated the same under a state franchise, doubtless no one would have seriously contended that the corporation's property interest in the highway gave it power to obstruct through traffic or to discriminate against interstate commerce. Right? So if they just owned a portion of the highway next to their businesses and and had that open to the public through a state license, a state franchise, right? The state allows a private company to own a section of state-owned property. They give them property interest in it, but they require them to run it in a certain way. When they do that, the corporation's property interests don't give it the rights to obstruct traffic or to discriminate against interstate commerce. You can't subvert constitutional rights just because it's private when it's held out for public use. And even had there been no express franchise, so even getting rid of the express franchise of government, but mere acquiescence by the state in the corporation's use of its property as a segment of the 4-lane highway, operation of all the highway, including the segment owned by the corporation, would still have been performance of a public function, and discrimination would certainly have been illegal. So even if you own just a little part of the internet that a lot of people go through, Zuckerberg, big website, even if you own just a little part of it, a little part is sufficient to make it a public service, a public function that just means that the public is entitled to some measure of its own constitutional rights on this service. Okay? That's important. And again, this is important because they're not necessarily saying that the company can't restrict all speech or, put a blanket restriction on speech, although they heavily imply that. They're really getting at the criminal charge for trespass. Get out. Get off my property because you don't follow my rules. Get off. Does that sound familiar? Because even though we don't have criminal charges, we do have companies saying get out. Next, whether a corporation or a municipality owns or possesses the town, the public in either case has an identical interest in the functioning of the community in such manner that the channels of communication remain free. In Trump's Twitter case, one of the distinctions the judge was making was that Twitter is a private service, but the portion of Twitter that Trump is on is public because he's the president of the United States and the public needs to have access to it. As we see here, there was a time in our country where it doesn't matter if it's the public or the private ownership of this segment of the public use. It's public. It's public. And it's public enough to protect the rights, at least the base rights of people on this property. Next, to act as good citizens, they must be informed. In order to enable them to be properly informed, their information must be uncensored. Now, they're not saying that you get a bunch of anime boobs, right? Like, that's not what they're talking about with the uncensored part. What they're talking about here is that Marsh, who's distributing this Jehovah's Witness material, can't be censored in the content of her speech. They can't censor it because it's Jehovah's Witness, right? They have to allow speech they're uncomfortable with to be disseminated because the people receiving it might be comfortable with it. Again, this runs into limits when we start getting to things like obscenity, lewd pictures, stuff like that. It's a little different. Right now, we're talking about handing out presumptively acceptable material for polite company. All right. Next, when we balance the constitutional rights of owners of property against those of the people to enjoy freedom of press and religion, as we must here, we remain mindful of the fact that the latter occupy a preferred position. Speech, press, religion. It's first. It's first. It's first. It's first. And it's first for a reason. It's not just first, though. It's distinct. The First Amendment has distinct protections for each of these things, right? Distinct. Property rights are important. Very important to the founders. Very. They liked slavery. Just kidding. Some of them did. Some of them, whatever. It's a joke. It's a joke. Property rights are very important. Very important, but they're also vague and they come after the First Amendment. Your property rights really start to shine in the Third Amendment. A little bit in the Second, right? Your right to own guns. The Third Amendment is the right to keep soldiers from being put on your property. The Fourth Amendment, the right to be secure in your person, property, and possessions. The Fifth Amendment, the right for the government not to take away your property without compensating you. You can see where we are here. First Amendment, primary among the amendments for a reason, and the court does look at it this way. It's speech, press, religion. These things are worth protecting more than other things. So in any balancing test, they get a little extra weight thrown on. Finally, this is the final quote from the case. In our view, the circumstance that the property rights to the premises where the deprivation of liberty here involved took place were held by others than the public is not sufficient to justify the states permitting a corporation to govern a community of citizens so as to restrict their fundamental liberties and the enforcement of such restraint by the application of a state statute. That last part, of course, being the crucial difference between what we have now, one of the crucial differences. The crucial legal distinction in procedure is that Marsh was convicted of a criminal act, a criminal trespass that was a state law. Again, until people start getting convicted of crimes for trying to access Facebook and Twitter, we don't have as much of a parallel as we'd like. But it's important to remember some crucial things. Gulf owned everything. about this town. However, we don't know that Marsh, and the court doesn't seem to consider the fact that Marsh lived there or not and utilized all the amenities of the town. All we know is Marsh was distributing stuff on a sidewalk and then thrown out of the town because it was a private property and she was engaged in speech they didn't like. That's what we know about Marsh. So there is a distinction there, but that distinction kind of fades away when we realize the court didn't care if she was using the plumbing system. She wasn't using a public water fountain or anything like that. She wasn't using she was standing in front of the post office, but if she doesn't receive mail there, then that service doesn't do her any good, right? This is an important distinction. Next, the court says public use matters a ton. Holding it out for the benefit of the private owner for public use. All of these are for-profit companies. All of them make ridiculous amounts of money. And they all are held out to the public. There's no special club. There's no fraternal order of Facebook users. They could do that. They could make it, like they don't even charge, right? Like it's for you. I mean, all the data that they collect and sell to a bunch of sleazy organizations and politicians, to a bunch of sleazy people, all of that stuff, you know, ignore that. You don't pay for these services, right? You don't pay for YouTube. You don't pay for any of this stuff. They have other monetization because they're holding it out for the public. It's better for them to have maximum public access and interest. Why? More money. They've figured that out. If you had to pay to use Facebook, it would go way down, way down. More access from the public means more money for the company. Mutual benefit. That mutual benefit really, really matters here. It really does. It's critical to the case. When you have that mutual benefit, it's held out to the public. Court says you've got to start recognizing the rights of the public at that point. Finally, Gulf owned the whole town, but the court says even if they owned a tiny portion of it, well, they don't say tiny, but even if they owned a segment or a subset of it, that would be enough. That would be enough. That if they owned a section of the road and then tried to restrict access to people that were trying to drive on that road, that would be unlawful. That would be a violation of rights, the rights of the people to use this public thoroughfare. Guys, we have so many parallels in this case to today. Don't get confused. Don't lose me now. Don't lose me now. This case cannot be applied to these companies directly. It is no longer controlling. It has been cast in a negative light by so many cases that followed. But it's very distinct, right? You have a company town versus an internet that didn't exist for another, several decades. And didn't exist in the form we know it as today, even for another 60 years, really. But it's close. It's close enough to matter because the philosophy, the underlying philosophy that these judges held, at one point in time, they cared more about the freedom of speech than they did about protecting the private property of companies making billions. Like, it's somewhere. It's in there. It's in there. We got to dig it out of them. I don't know what we have to do. I don't know. But Marsh is a start. Learning about Marsh, caring about Marsh. Attorneys out there starting to cite Marsh more and more in freedom cases. It hasn't been overturned. It's negatively treated. It's been modified. It's been minimized. It's been distinguished. Hasn't been overturned. Start drawing the analogies. Start building it up. Start building it up. Get a body of case law that starts to recognize Marsh. This is a long game, folks. It's a long game, but we need it. Anyway, I hope this helps explain Marsh versus Alabama. I hope I'm not missing anything in this analysis. If you think I am, leave it in the comments. Hit me up on Twitter, whatever it takes. But seriously, guys, we've got to stop. We've got to stop saying these private companies can do what they want with our speech. It wasn't always this way. It wasn't. We didn't give immunity to these companies for what they do to people. We don't need to do it now. The Communications Decency Act 230, I'm coming for you. I'm coming. That video is coming. It's coming. Because we've got to stop. We've got to stop, or we're creating a shadow government that's unelected, effectively immortal because they'll control the flow of commerce because Congress won't be able to do anything about it. Effectively, how will they? How will they communicate, right? When the companies don't let them. How will they do it? If we give all of the power to unelected companies that people buy by enjoying cat videos, we'll never get it back because cat videos will always be popular, always be shared, and a bunch of people will always be asleep. We've got to start now. We've got to start now. Thanks, guys. Have a good night.